Having worked as a lawyer and served in the judiciary for so many years now, I have to say that the Constitution of India has always impressed me deeply. If we take a look at Part 3 of the Constitution of India, the chapter on fundamental rights, we see that it contains a number of rights which other countries have not categorized as a fundamental right. For example, under Article 19(1), the right to information has been given the status of a fundamental right. Every citizen has freedom of speech and expression and also has the right to know how the government works and what role it plays. Another example is Article 21(a), the right to education, which was introduced in 2010. But the crucial point here is, does it make a difference when we have such rights as fundamental rights enshrined in the Constitution itself? The answer is yes, it does. The judiciary itself obtains its legitimacy from the Constitution. In other words, the Constitution itself provides for the establishment of the judiciary, which is commonly recognized as the third arm of government. Now, what is the role of the judiciary? The function of the judiciary is to interpret and to apply national constitutions and legislation consistent with international human rights norms and international law to the extent permitted by the domestic law of each country. In that respect, therefore, the judiciary plays a key role in upholding the rule of law in any country. This brings me to a very important issue, that of the independence of the judiciary. Many, if not all, constitutions of the world are based upon the principle of the separation of powers, which requires that each of the three branches of government, executive, legislature, and judiciary, should have clearly defined roles and should operate independently without encroaching on one another's powers. It is clear, therefore, that when the executive or the legislature acts to remove judicial officers without due process, this is a matter of serious concern and leads to the erosion of the independence and impartiality of the judiciary. It further erodes public confidence in the legal system as a whole and undermines the rule of law. For these reasons, it is very important to constantly take steps which strengthen the independence of the judiciary. There are, of course, differences which exist between the two systems. One notable example is public interest litigation. Whilst in India, a member of the public acting bona fide can move the court for relief where fundamental rights are allegedly infringed on behalf of a person unable to do so because of poverty, disability, or social position. In Mauritius, there is need for a relevant personal interest in order to have locus standi. Mauritius is going through a phase of reconsidering its arrest and detention procedures after years of criticism of the current system of provisional information and inquiry after arrest. How to limit the time spent in police detention, how to ensure safety of a detainee whilst in police custody, the right to counsel. Can this be curbed in dangerous drugs cases where the police may need more time to inquire or set up a controlled delivery exercise? Do all statements given in police stations have to be video recorded? Is there a need for the setting up of strict time limits for a criminal case to reach trial within a reasonable time? Are all issues which are currently being considered and debated with a view to reforming this system. Mauritius has inspired itself from the Indian experience all these years, and I'm sure that we will continue to do so and continue to work in close collaboration. In my view, there's so much more that India and Mauritius can exchange in the legal arena. The judiciary in particular would benefit immensely if regular exchanges or training programs could take place. We would definitely welcome any such initiative or invitation in the future.
Of course, Excellency, we are very glad to work with the Government of Mauritius and the judiciary to support the new building of the Supreme Court. We are already very advanced in discussions with the Indian National Building Construction Company and the Government of Mauritius. So my hope is in about 2 years' time, we should be able to have the new building of the Supreme Court of Mauritius ready. Honorable Chief Justice, let me assure that we will transmit the very important remarks made by you to the Supreme Court of India and try and work out an MOU for sustained cooperation so that we have a platform on which we can have legal fraternity from both sides meet regularly and take our cooperation forward.